Morning.
Morning.
The record reflect we are back in session. Public counsel are present. All members of our jury or alternates are present. Our witnesses back on the witness stand. And Ms. Rodriguez, you may continue your examination.
I just have a couple of more questions for you. Did you at all consider or review any of the records from the earthinspiredproducts.com account that was opened by Mike McStay? A Chase Bank account?
I don't recall that we did.
Okay. And so you didn't consider any money that Susan Blake wrote to, or checks that Susan Blake wrote to the defendant after Joseph McStay went missing?
We did look at the checks that were, and if that's the account they were from, I apologize, but we did look at checks from Susan Blake at that time, yes.
Okay, when you say at that time, when was that?
The post-disappearance.
Okay,
yeah.
Before, so when you initially started the case, you looked at those checks? Sometime in there?
Sometime in there, yeah.
That wasn't something new that you just looked at?
No.
Okay. And when you testified previously, you testified that there were instances where you would see the defendant making deposits into Joseph's account. Do you recall testifying to that?
Yes.
And just to verify, you didn't, or you weren't implying that when the defendant would make those deposits into Joseph's account, that was actually the defendant's money that he was depositing, right?
That's correct. I wasn't implying that.
Okay, so you were just implying that he would drop off checks from customers or something like that?
That's correct.
Okay, nothing further, Your Honor.
Anything on redirect?
Thank you. Good morning, sir.
Good morning.
Yesterday you heard you got a lot of questions about Mr. Merritt's bank account, transactions that he did in terms of cash withdrawals. Do you recall that line of questioning?
I do.
Now, in terms of what your, the request that came in from our office as to what you should be analyzing as far as our perspective, do you recall what that was?
I do. I was tasked with looking at to see if there was any potential gain to either Mr. Cavanaugh or Mr. Merritt from the disappearance and death of Mr. McStay. And we defined that in our analysis as gain from that would have been extraordinary, if you will, above and beyond what was routinely business. So when we did the analysis over bank accounts and PayPal accounts and all that, when we looked at cash or payments, personal payments, that sort of thing, it was just to distinguish that from business records. That was the purpose of that.
So task number one was there a gain or not for Mr. Merritt or Cavanaugh?
That's correct.
Resulting from the disappearance of Joseph McStay? That's correct. And then were you asked to look at another issue?
We were asked to look at whether there was a debt, in particular a debt of Chase Merritt's to Mr. McStay.
And more specifically, what time frame were you asked to look at to see if there was a debt?
The connection was to an email that was generated, I believe that was 2/1/2010, and with that, the data that came along with it were those ledgers that had records from 2007 through 2009. So that was the time frame that we looked at and what the reference to the debt was.
Now, on the issue of the question of whether a debt is owed by Mr. Merritt to Mr. McStay, as of the date of that email, which was February 1st, 2010, correct?
That's correct.
Is it useful at all to know what Mr. Merritt spends in his account?
Again, the only distinction that we made was to look to see what was personal, so that we didn't confuse personal spending with business spending, but we didn't do any analysis of what that personal spending was for.
Would you need to do an analysis of Mr. Merritt's spending in order to determine if a debt was owed to Mr. McStay as of February 1st, 2010?
not his personal spending.
Did the February 1st, 2010 email that council originally brought up, and you know what email I'm talking about?
I do.
Exhibit 419?
Yes.
Did that email give you a starting point?
It did. And there's data on that email. It's fairly terse, but we were able then to type that back to the ledgers for verification.
How important were the ledgers in determining whether or not there was a debt owed and what type of debt, if any, was owed by Mr. Merritt to Mr. McStay?
They were critical.
How so?
We had no corroboration and no backup for any of the figures that were on that email without the ledgers.
And no backup for the checks, the hundreds of checks that were issued to Mr. Merritt from Mr. McStay as well.
We had copies of checks, but we didn't know what jobs they applied to or where they went.
How did the ledgers clarify all the checks that were issued from Mr. McStay to Mr. Merritt over that period of time of 2007, 2008, 2009?
It helped in a number of ways. We were able to see that there were checks that were written to third parties that were applied to Mr. Merritt. They were credited to him, if you will, on what amounts to a job costs ledger. So we were able now to track from the ledger what the job was, how much would have been owed to Mr. Merritt, and how that was paid, and whether in fact it had been paid in total or not, if there were still outstanding obligations.
So let's say, hypothetically, Mr. McStay issued a check to Mr. Merritt, and the check was, he didn't give a reason why the check was issued. Would that check then, would you see that check on the ledger?
Yes, so if it was a job-related check, it would have showed up on that ledger in one form or another. Typically as a payment, so if you remember, there was a column that said Chase owed, and then there were columns for payments. And so those checks would accumulate against a particular job, could then track those checks and say this is where it was.
And we saw the three columns that said Chase's money, and then it said first payment, second payment, third payment. Do you know what I'm talking about?
I do.
So whatever Chase's share was for that job would be issued in a series of checks.
Action asked to answer cumulative 352.
I'm sorry, could you just repeat?
Sure. When we had the amount owed to Chase in those columns, and then there would be a series of payments, those theoretically would match up to the amount of money Chase was owed, correct?
That's correct.
For that job.
For that job, which was indicated by the 0 on the far right of that spreadsheet.
So, let's say Chase was owed, hypothetically, $10,000, or the job was $10,000, and we're talking about the 65% model that you spoke of. Therefore, Chase's money would be $6,500, correct, for that $10,000 job?
That's correct.
And let's say 3 checks were issued to Mr. Merritt, $2,000, $2,000, and $2,500. Okay? Let's say Mr. Merritt, with one of those checks, decided to go to Vegas and, as the prosecutor likes to say, gamble. And he gambled $2,000 of it. How would that affect your analysis?
It didn't have any effect on my analysis.
Can you explain to the jury why?
Certainly. The reflection on that ledger was of what he had been paid, not with what he did with that money. So those payments were reflected as either directly to Mr. Merritt or to third parties on his behalf. And any money that went directly to him was just part of what was owed to him for that job. We didn't look at where he might have spent that money.
So $6,500 that Mr. Merritt would be owed on that hypothetical job of $10,000, as long as it's zeroed out, and as long as the job got done, that satisfied the requirement. Is that correct? Satisfied the requirements for that job.
Objection. That calls for speculation.
Sustained.
Did the ledger have any confirmation to it that the jobs were being finished?
What we read as the confirmation that the job was finished was that there was no, and relative to Mr. Merritt, the job was finished. There was now a zero on the balance owed. So that was our indication.
Non-responsive, speculation lacks foundation.
Overruled, answer remain.
You said earlier, when counsel was asking you about the relationship, she said you know the relationship, they had two separate companies, correct?
That's correct.
So, if one company is supplying another company a product, in this case, Mr. Merritt's company is supplying a product to Mr. McStay's company, which is a waterfall, correct?
Yes.
And when that waterfall is delivered, what that company does with the money they got for their waterfall, is that relevant to the issue of whether a debt is owed?
No.
Okay. I want to talk about that 65% model and 15% model.
Okay.
Can you just explain, because to me, 15% sounds like a heck of a lot less than 65%. But does that necessarily mean Mr. Merritt was making less money when it switched from 65% to 15%?
The big distinction between the 65 and the 15 was who was primarily responsible for paying for fabrication. In the past, when it was 65%, kind of on average, that was appears to have been the target. Chase was the person who was doing the fabrication and therefore buying the materials for the fabrication, performing the labor for the fabrication.
Objection, that calls for speculation and hearsay.
Overall, it's based on his opinion and based on the review of the records.
So when the model then was changed from 65 to 15, the principal supplier for the fabrication was Metro Sheet Metal or someone else. There were some instances perhaps of someone other than Metro Sheet Metal. So Mr. McStay would be paying for the fabrication and therefore the materials that went into that fabrication to someone else other than Chase. That amount of money then, with its work and the purchase of the materials and so on, bypassed him, but he was still paid a fee for pulling it together, buying other materials, and...
Objection, that lacks foundation. It's hearsay and Sanchez.
Sustained and to the effect that it's going into what he was specifically doing and what the compensation was for.
Motion to strike is answered.
So the last portion of the answer is stricken, the jury's instructed to disregard the last portion of the answer.
In this case, when the model switched from 65 to 15%, when Chase was getting 15%, when that's, I think you said it was October of 2009, correct?
That's correct.
When Chase was getting 15%, he no longer had to pay Metro Sheet Metal, correct?
That's correct.
And that was a huge cost, correct?
He no longer had to pay Metro Sheet Metal or to buy materials for fabrication.
So, let's use that same $10,000 job hypothetically. If Chase got $6,500 but had to spend $5,500 on fabrication, his profit would be $1,000.
Objection, improper hypothetical to assume facts not evidence.
Whatever he had to spend on it, that would be his profit, correct? $6,500 he gets. He has to spend X amount of money, hypothetically. The resulting amount is his profit, correct?
Objection, this again assumes facts not in evidence.
Overruled.
Speculative.
So the 6,500 would go to buying materials and pay for his labor. Profit's a little bit of an interesting word here because he's also working to do this. So
Objection, that's hearsay with a strike.
Overruled.
the money then is that what you referred to as profit is what's left over for him, whether it's to pay him for his time and effort or whether it's some excess is unknown.
In the email, we saw 15%, and then we saw plus savings. Do you recall that?
I do.
Did you understand through the records what that meant?
My understanding of that was that it was material savings or fabrication savings because of his expertise in negotiating,
Objection, speculation.
Overruled.
finding the appropriate people to do the work, was that nature of things. There was also installation on one of the 2 jobs that were listed on that.
So he could theoretically get 15% on a job plus the savings and make more on it than he would if he got the 65%.
Objection, speculation.
Overruled.
So if I understood your question, it was he could, and it would be possible, yes.
Now, the email contained those 2 jobs, Saudi Arabia and Paul Mitchell. Do you recall that?
Yes.
Did something happen that affected that model, 65 to 15%, or did something happen in your analysis that affected that model of 65% to 15% for those 2 jobs? Let me ask you this. Let me ask it a different way.
Okay.
Did Joseph's disappearance cause that model to change?
Objection, that calls for speculation.
If when the model switched from 65% to 15%, you indicated that Joseph would then have to go and directly deal with Metro Sheet Metal, correct?
Objection, that calls for speculation.
Overruled.
So yes, he would have to. He was the one who was making the payment to Metro Sheet Metal.
So after February 4th, if Joseph disappears and he's no longer there to pay Metro Sheet Metal, to get the Saudi Arabia job done, to get the Paul Mitchell job done, through your analysis of the records, whose shoulders did that fall on after Joseph disappeared?
Objection, that calls for speculation.
Who then issued the checks to Metro Sheet Metal?
There were Dan Cavanaugh issued payment to Metro Sheet Metal, and there was money for supplies that, in my opinion, were spent by Mr. Merritt for
Objection, that
supplies.
calls for speculation, assumes facts, not evidence, and possibly hearsay.
Overruled.
You can finish.
So in your question was how did Metro Sheet Metal get paid, and we have record of Dan Cavanaugh paying him rather than Joseph McStay paying him under that model, and there's also the jobs were finished, the materials had to have been purchased by someone. It was, in my opinion, reasonable to assume that there was money that flowed from Mr. Merritt for that as well.
Objection, speculation.
Overruled.
If Joseph wasn't around to have the waterfall broken down, crated, and shipped to Saudi Arabia, could you see that also affecting that 65-15% model?
Objection calls for speculation.
Well, hypothetically, if now Mr. Merritt was responsible for getting the waterfall broken down, crated, and shipped, would that change the costs associated with that job?
Objection, improper hypothetical.
You asked some questions about Mr. Cavanaugh's spending, is that correct?
Yes.
And you were shown some PayPal records, is that correct? She put some PayPal records up on the screen, and you were able to look at those, and she asked you specifically about some spending that occurred in February from Hawaii. Do you recall that line of questioning?
Yes.
Okay. Is it your understanding that that spending was through wire transfers, through the use of an ATM card, or how?
Well, again, we didn't take a deep dive into the personal spending of either of the parties that we're talking about here, but the PayPal records would indicate that it was indicated that I think it was a debit card or a PayPal-related card.
in your experience, and you're she mentioned the term CFE. Can you explain to the jury what CFE means?
A CFA refers to a certified fraud examiner.
And have you sat for, taken, and passed that exam in the state of California?
It's not a California exam, it's an association exam put on by the Society of Certified Fraud Examiners, and I did take the exam and passed the exam several years ago. I am no longer active in that organization, however.
Okay. But as a CPA, do you get ongoing training in fraud examination?
I do.
So, in your experience, is it uncommon to have someone give a credit card or a debit card to someone else to use?
Objection, speculation.
Sustained.
Have you seen in your analysis of financial records that the person who owns an account may allow others to use a debit card or a credit card?
Same objection.
Sustained on both background as well as relevancy.
The second part of your analysis that you indicated that you were asked to do, or maybe it was the first part, is to do a gain or loss analysis based on the disappearance of Mr. McStay. Is that correct?
That's correct.
Can you explain to the jury what specifically you were tasked to do?
Objection beyond the scope, cumulative.
Overruled.
So my task when I was assigned to look at gain was to see whether either Mr. Cavanaugh or Mr. Merritt gained from the disappearance and subsequent death of Mr. McStay. What we looked for, we didn't look for loss necessarily, but we looked for gain to see whether there was something unusual that accrued to either one of those outside of what their normal, ordinary business activity had been. They both had a business activity, they had business interactions, and there would have been monies earned by both of them in the ordinary course of that relationship. So we were looking to see whether there was something that was outside the pattern that had been established over time. So that's what we were looking for.
And a review of the, now would it be safe to say that the report that counsel was referring to when she was asking you questions mainly dealt with that question?
In fact, it was pretty much exclusively about that issue. That was produced as a status update in the middle of July last year. So.
Okay. And based on the records that you reviewed and that question, did you have an opinion as to whether or not Mr. Cavanaugh benefited or didn't benefit from the disappearance of Mr. McStay?
I did form an opinion about that, and it was my opinion that following his death there were things that were outside of the normal relationship that had been demonstrated over time. We examined a lot of records and looked at his relationship and his earnings as a service provider for Earth Inspired Products. There was a period of significant income in what I referred to as a growth period. Then there was a decline in that, and for the last year or so he earned significantly less money than he had previously, and then almost immediately after the disappearance, his income from Earth Inspired Products went up significantly.
So, did you have an opinion as to whether or not Mr. Cavanaugh gained from the disappearance of Mr. McStay?
Yeah, so under the parameters we were working with, I called that a gain.
Okay. Now, you testified yesterday that Mr. Cavanaugh continued receiving payments after Mr. McStay disappeared, after February 4th, 2010. Mr. Cavanaugh was, I think the term you used may have been redirected, the money to his PayPal account that was coming in from the online orders through PayPal. Is that correct?
That's correct.
Objection, the state's testimony.
And it's speculative.
Overruled.
In addition to PayPal, you indicated there was a second source of where he would get the money in, take the money in for these orders. Is that correct?
I did.
And what was that source?
Well, we also saw cash deposits outside of PayPal.
Objection, speculation.
Well, just a minute. Overruled, yes,
So if I can explain where we saw that, the report that we, or the sheet that we looked at yesterday indicated there was a specific account. There were two accounts that were, there were cash receipts. One of those is a business account. It was a business checking account with Bank of America. In my opinion, deposits made into a business account are business related. And if I don't recall, I'd have to look to see what the amount of that one was. But the second one was a personal account that was used, that account commingled business and personal funds. And there were substantial deposits that we were able to identify that were business related. There were some deposits that were cash deposits that we couldn't identify. They were made at an ATM. We don't know whether they were checks deposited or cash.
All right. I think you referred to them as ATM deposits.
I did.
So whether a check was deposited or whether cash was deposited at the ATM, you don't know.
I don't know.
But my question is, PayPal was the source that Mr. Cavanaugh was receiving these payments for these orders that came in online, correct?
That's correct.
And another place that Mr. Cavanaugh was getting that money was into his bank account, is that correct?
That's correct.
And what was the total of that amount from February 2010 to December 2010, the 10-month period?
The amount that we attributed to business revenue over that period of time was just under $207,000.
And of that, there was some question about cost of goods sold. Do you recall that?
I do.
And cost of goods sold you defined as, I believe, purchasing the waterfall to send to the customer, correct?
Objection, asked and answered, cumulative.
overruled.
Yes.
So you have an amount of that, of what that figure was.
I recall it just over $58,000.
So just because I'm not that great at math, 206,000 minus 58.
It was 207 minus the 58.
Sure.
How about if I pull, I may have that handy here. So that would have left in $147,500 of gross profit.
Now, that $147,000, counsel then asked you a further question about another $58,000 that somehow she asked you to subtract from that $147,000. Do you recall what that amount was?
Objection, misstates testimony.
Overruled, we can answer if you understand this question.
Yeah, the two amounts that she had asked me to subtract from that were the ATM deposits.
Okay. But in terms of the actual revenue brought in and the cost of goods sold, you said $147,500, correct?
Of gross profit, yes.
Okay. Now, of that money, $147,500, did you see anywhere in the records that Mr. Cavanaugh sent any portion of that $147,000 to the McStay family?
No, I don't recall seeing any of that, seeing anything given to the McStay family, no.
Okay. But you did, when she asked you about the spending related to that, you did indicate that there was personal spending, is that correct?
That's correct.
Were you able to determine how much you attributed to personal spending of that $147,000 that Mr. Cavanaugh spent?
Objection, improper, violates the
The
elimination.
objection sustained is on relevancy grounds.
What was the total amount that you came up with as to personal spending?
Objection, improper relevance.
Again, sustained relevancy grounds based on the court's previous eliminating rulings.
What about the cash that Mr. Cavanaugh withdrew from either PayPal or his bank? Did you have a total figure for that?
Same objection.
Sustained.
At this time, I'd ask court to admonish counsel.
Objection sustained.
Did that factor of the amount of money you took in, the $206,000, did that have was that a factor in determining whether or not Mr. Cavanaugh gained from the disappearance of Mr. McStay?
It was a factor, yes.
Were you able to determine through the review of your records whether Mr. Cavanaugh was authorized to receive that money on behalf of Earth Inspired Products?
Objection, lacks
Sustained,
foundation and speculation.
sustained, calls for speculation and conclusion.
As far as Mr. Merritt is concerned, you did review his records as well, correct?
That's correct.
In terms of after the disappearance of Mr. McStay, did you have an opinion as to whether Mr. Merritt either gained or lost from that disappearance financially?
My opinion was that he completed the jobs that were underway.
Objection, calls for speculation and misstates evidence.
Overruled it, he understands as his opinion.
Go ahead, sir.
So the jobs that we had visibility to were completed to the best of our knowledge. We found no evidence of any claims for unfinished work. Payments were made in full on those jobs. The gain would have come just through the normal completion of the jobs rather than anything extraordinary.
So, did you have an opinion as to whether he gained or did not gain from the disappearance of Mr. McStay financially?
So, as I stated before, we were looking for things that were outside the ordinary scope of business. We didn't find any gains outside the ordinary scope of business with his relationship to Earth Inspired Products.
You did mention earlier that on questioning about Mr. Merritt's account that you did not see that he had any other, or the question was asked whether you saw any other source of income from Mr. Merritt. Do you recall that question?
Yes.
Did it appear to you that Mr. Merritt was sole source of income was working with Earth Inspired Products?
To the best of our knowledge, we didn't, I would say that that's correct. We didn't see any evidence of income from other sources.
Counsel asked you about Geist Construction. Do you recall her line of questioning regarding Geist Construction?
I do.
And the wire transfers that she showed you, I think one was went into Dan Cavanaugh's account, correct?
I believe that was the $6,250 one.
And that was, and then she showed you a corresponding $5,000 transfer to Mr. Merritt, is that correct?
That's correct.
And then there was another $6,250 sent to Susan Blake. Do you recall that?
Yes.
Okay. Now, those transfers, to your knowledge, those were after the disappearance of Mr. McStay?
Yes.
Is that one of the reasons why Geist Construction really didn't factor into your analysis of the issues that you were working on?
Yeah, it just never came up on our radar, frankly.
Okay. Now, you recall a line of questioning regarding QuickBooks.
Yes.
And you were explaining what QuickBooks is. I think you made you don't rely on QuickBooks or something like that. I don't remember your exact words. First of all, as you understand it as an accountant, as a CPA, what is QuickBooks?
Objection, relevance beyond the scope.
The objection sustained is cumulative.
Did you review the QuickBook records, for the custom and the regular account?
We looked at all of the records, QuickBooks records, but as I said, we didn't rely on them because without cooperation, they're not reliable. So we based our analysis on banking records.
Now, counsel limited her questions to the custom account when she asked you about that.
Objection, that's already been.
Sustained.
well, I'm gonna ask you about the regular, I think we refer to it as the main account, the contact account. Do you know, when I use those terms, do you know what I'm talking about?
I do.
Okay. Did you get a chance to review the activity logs, or maybe I'm using the wrong term, audit logs? Did you review logs of that account in QuickBooks?
We did examine them, yes. I believe activity logs may be the correct term.
And were you able to notice whether or not, when that started approximately? Or at least when you started reviewing the records from that account?
From the, reviewing the activity logs?
Yes.
I don't recall the specific start date on those.
Okay. Would it be fair to say that that account had more records than the custom account?
I don't think I ever made the distinction between that for line items, I'm sorry.
Okay. Would it be, in reviewing those logs, did you notice whether or not the account showed that checks were written in that account, just like we saw in the custom account?
Certainly.
Objection, Lax Foundation based on his previous answer.
Sustained.
Did you review, when you say you didn't look at it line item, are you saying you didn't look at each and every line? Or what are you saying? Or did you review the records? What did your review entail?
No, we reviewed the records. What I tried to say and perhaps didn't say was that I didn't count lines. I couldn't tell you how many lines were in each of those different sets of books.
When you reviewed those records, did you see that checks were issued that were noted and recorded in the contact account?
Yes.
Were checks deleted in the contact account?
Yes.
Did that happen on a fairly regular basis that you were able to see?
No, there was a fairly large group of deletions. I believe it was in the latter part of 2010, the summer of 2010. I don't remember the exact date.
So I'd object as to relevance, move to strike.
Sustained.
If I showed you some of those logs, I didn't bring them all because it's 980 pages or something like that. But if I showed you the logs for the relative time period, would that refresh your recollection?
Sure.
Vegas to relative time period.
Well, you said it's toward the latter part of 2010,
And there's
right?
an objection as to relevance.
Sustained.
Well, counsel asked you about activity after the disappearance, is that correct?
Yes.
She asked you a whole host of questions about checks that were issued to Geist Construction and other companies after February 2010, is that correct?
That's correct.
Objection, misstates testimony.
Sustained.
Was there, well, you mentioned that there was did you mention that there was a sale of the company in July of 2011?
Objection, Lax Foundation calls for hearsay. It's also cumulative.
Overruled on that ground, but sustained as cumulative.
Okay. Do you know whether or not entries were made in QuickBooks in the custom account, not the custom account, the contact account, that had to do with the sale of the company?
Objection calls for speculation, Lax Foundation, hearsay, and relevance.
Overruled.
I don't recall seeing the sale of Earth-inspired products in the QuickBooks records. We examined a sales document that was for the sale of the company.
Therefore, I object, Lax Foundation, move to strike his answer.
Overruled.
Was there a balance sheet that was created in QuickBooks that you were able to review?
There was a balance sheet in QuickBooks in 2010, I believe, that was strange at best. It had all of a sudden showed
Objection, relevance.
Sustained on that ground and also the foundation.
Move to strike any answer.
Well, there wasn't an answer.
were you able to determine in the custom account how many total checks were issued from that account that were
Checks
noted
and
in
relevance.
Sustained on relevancy grounds, cumulative and evidence code 352.
nothing further? Thank you.
Anything on, recross?
Yes, thank you. So,
Physical or virtual?
so one of the things you were asked to do was look at the potential gain to the defendant and to Mr. Cavanaugh, right?
That's correct.
And you testified that your opinion was that there was a benefit to Mr. Cavanaugh, but not to the defendant, right?
That's correct.
And so we see exhibit, what is it?
419.
419, which is the email that we talked about yesterday, right?
Mr. Jackson, can we have my computer, please?
Correct.
And in this email, we see from the defendant, or we see a message to the defendant that says, this is what you owe me, $42,845, right?
Objection misstates the document.
Overruled, he can answer if that's his understanding of what it shows.
Yeah, that's not my understanding of what it shows. That's-
Okay, so when he says, as of 2/1, Chase was paid this amount, Chase was owed this amount, and he was overpaid $15,000, plus you owe me $8,800 for the Levine job, plus $19,000 for Provencio, and the total is $42,845. You're saying Mr. McStay didn't mean to say that the defendant owed him that money?
Well, counsel's misstating what the email says.
And it's argumentative.
Sustained is argumentative.
You're indicating, and what your testimony is that that's not what the email says, right?
Yes, that's correct.
Despite the fact that that's what we see written there, right?
Objection argumentative.
Sustained.
And so, if Mr. McStay actually intended this document to mean that the defendant owed him $42,845, and Mr. McStay was then gone, I guess that debt disappears, right?
Objection argumentative.
Sustained.
Well, he wouldn't have to pay him that money, would he?
Objection argumentative. And
Sustained.
And you didn't consider this email to be a debt, did you?
I didn't consider this to be a debt of $42,845, and any debt would have been to Earth Inspired Products, which continued beyond the death of Mr. McStay.
And you indicated that those ledgers that you received, those were pretty critical to you, right?
They were?
And when you reviewed the ledgers, you made a chart that indicated that the defendant had been overpaid by $15,045, right?
On that particular day, yes.
And then after that, we see another $15,000 plus in checks that the defendant receives, right? After this email.
He continued to receive money on payment for jobs, yes.
And continued to receive payment for money on jobs that was backdated to, the checks were backdated to February 4th, right?
objection misstates the evidence that
Overruled, he can answer whether or not that's correct.
I believe that the date on, you're referring to 3 checks, is that the checks you're referring to?
The checks in QuickBooks.
Yeah, so I believe that there were dates of 2/2 and 2/4 on those checks, that's my recollection.
Okay, and when you looked at the QuickBook records, did you look to determine and see that there were edits changing the date back to February 4th?
Yes, I believe we covered that yesterday.
And so, looking at this email and reviewing information in the records, is it your testimony that this $19,000 on the Provencio job was not owed to Joseph McStay?
As I've described earlier, this is a continuance of a note that's been on the 2007 for, I think it's Levine or Provencio, one of those, in 2008, and now again on 2009 ledger. There's not apparently been an attempt to collect this as if it was a debt.
So
It's
you
still-
don't, go ahead.
It's still just a note on the side. I see that it's here, but it's, in my opinion, not part of the overpaid. If it was meant to be in the overpaid, you'd have put it there.
So you don't see this as an email from Joseph McStay to the defendant saying, this is a demand for payment, this is what you owe me?
Objection asked and answered.
Overruled against you.
No, I don't see it as that.
Okay. Now, you testified, let's talk about this 65-15 model, the 65% and the 15% model. When he got the 65%, he was doing the fabrication, right?
That's correct.
So he could do essentially, in your words, whatever he wanted with the money, right? With his portion.
So I believe what I said was that he could do whatever he wanted with what he made from that. Certainly he couldn't spend that money and not provide the product. And the evidence that he provided the product is from the ledgers that show that there was nothing, no balance due. The projects were done.
Okay, so you're assuming that because it says a zero balance, the projects were done, right?
It's my opinion that that's what it meant.
Despite the Provencio job and the Levine job, right? So it says zero balance on there, but we know there were disputes about that, right?
Objection, disputes are not completing the job.
Overruled.
So repeat your question, please.
So your testimony is that because there was a zero balance, that $19,000 debt didn't exist and the other debt with Levine didn't exist because there was a zero balance in the ledger?
So what I said is that the zero balance indicated the project had been completed.
Despite the fact that you reviewed PayPal records and other records to indicate that there was an issue with the Provencio job.
Yes, there was a claim made. He did not go back and redo his ledgers. From what we have, they still reflected zero and there was no new claim on them.
And so the defendant would get on that 65% model, he would get that portion and he had to pay for supplies, right?
Yes.
But you're not aware, or are you aware, of what the defendant would spend on supplies?
We can see from invoices to customers of certain things that are in addition to the fabrication work. So we'll see that there were glass and pumps and valves and other things that needed to be provided. So we know that there's other supplies besides the fabrication.
Okay, and what percentage of that 65% was actually spent on supplies?
I can't tell you that.
Well, you wrote in your report that records show that 10% of Merit supplies, Merit's receipts were used for supplies and tools, etc., right?
At the time that we wrote that, we didn't have this information from the ledgers. We didn't have specific job expense information. So that was our best estimate at the time.
Okay, and showing you 1134, which were the checks that you looked at yesterday. You recall these checks, seeing those?
Yes.
And would those be examples of checks that the defendant would write for supplies?
Certainly many of these appear to be for supplies. San Bernardino glass, obviously. I don't know what graphics would have been, but yes.
Okay. And when you look at those checks, you certainly see the fact that some of those checks bounced multiple times, right?
Yes.
And did you compare these with the defendant's bank records to determine if they were actually ever paid?
We did look to see whether they've been paid. Some of them were and some of them were not, in terms of checks clearing.
And did that have any impact on your analysis in this case as to the defendant's financial status?
we weren't examining this to see what his financial status was. That wasn't our purpose to see whether he managed his bank account well.
Well, would it not be important to know what his financial situation is if you're looking at a potential gain or loss to somebody?
So we looked to see whether there was things outside the ordinary course of business. We relied, for my opinion, I relied significantly on the ledgers, which demonstrate that he finished these jobs. So whether he finished them by writing checks for materials or paying cash was irrelevant. He had satisfied those jobs to Mr. McStay's satisfaction so that they were listed on ledgers as complete with nothing more owed.
Okay, so let's go back to the question that I actually asked you, which was, would it not be important to look at the entire picture of the defendant's financial situation in order to understand whether or not there was any gain or profit or loss to him with respect to the disappearance of the McStays?
So I don't know how to answer the question better than I just did, so I'm going to have to let it stand. I don't know. I did not examine his financial well-being. I looked at his business relationship with Mr. McStay.
Well, you did that with Daniel Cavanaugh, though, right?
Did what?
You went through and examined his financial well-being, right?
We looked at what he earned.
So if we have a reduction from 65%, using the example that you provided, the 65% to 15%, right? On the 65%, we didn't care if the defendant went and spent $2,000 on gambling, right? Didn't matter how you spent that money, right?
It didn't matter to me if the job was complete, how he spent his profit.
And if he's making 15% and wants to spend that same $2,000 on gambling, does that not matter in looking at the defendant's financial situation?
Again, it doesn't matter to me in my analysis of what he spends his earnings on. When he completes a job, the earnings are his.
You don't have any information when we went through those checks yesterday, because you testified again today that the defendant paid Metro Sheet Metal prior to, I think it was the October time frame. There is no evidence before you that the defendant paid Metro Sheet Metal, is there?
We don't have checks to show that he paid checks to him, but there were payments made on his behalf that were attributed to him.
My question to you, sir, is there anything in the defendant's records that indicates to you that he paid Metro Sheet Metal?
There are no checks that he wrote directly.
And so when we look at that exhibit that you did with respect to Paul Mitchell, where you represent that he paid $3,600 to Metro Sheet Metal for the completion of that job, that would be pure speculation on your part, right?
Misstates his testimony, Your Honor.
Objection sustained on that ground as well as cumulative.
You testified about that email and the savings section. Do you recall that?
Yes.
What evidence do you have to support that the savings would be passed on to the defendant?
The email said that was totaled $26,000 for those two jobs. The only way for that to total the $26,000 was to include the savings that was on each of those lines. So he was showing that this is what was going to be due to Chase. 15% plus savings, and in Saudi Arabia's case, $4,000 for installation.
So it's speculation on your part that the savings would actually be paid to the defendant.
Objection, misstates.
Objection sustained as argumentative and misstates the testimony.
You don't have any independent information to explain what that means, do you?
I do not.
And you indicated that part of your analysis was the fact that there was an income decline with respect to Dan Cavanaugh, right?
That's correct.
And wouldn't the same also be true of the defendant if he was no longer making 65% but was making 15%?
Vaguest the time as to when the decline was, Your Honor.
Overruled.
Can you repeat the question? I got lost in the shuffle.
Sure. You testified that there was a decline in income, and that was part of your analysis that Dan Cavanaugh was receiving less money, right?
Yes.
And wouldn't the same also be true of the defendant if he previously had been receiving 65% and now he was only receiving 15%?
So the decline in revenue, the top line, if you will, is true, but there is not necessarily a decline in profitability or actual take-home earnings from that. With Mr. Cavanaugh, he was being paid for his specific time. He was no longer actually earning any money.
Well, you don't have any information that he wasn't actually earning any money, do you?
Well, what we have is that he, in that last period of time, averaged less than $1,000 a month compared to what he'd been doing before.
And you have no independent knowledge as to what other businesses he had going, do you?
Your Honor, I'm going to interject. If counsel could clarify what time period we're talking about.
Overruled.
So I don't have any idea what his other sources of income were, but my analysis was relative to Earth-inspired products, not the size of the universe. So I don't know how to do that.
I don't think I asked for the size of the universe, sir. I think we're talking about what your testimony has been. And you indicated that Mr. Cavanaugh's income had declined, right?
His income from Earth-inspired products had declined.
You have no information as to what other sources of income he had at that time period was, do you?
It wasn't relevant to my analysis.
And in fact, the records that you reviewed showed that Dan Cavanaugh actually was trying to run the company, right? He was spending money on supplies, right?
After the McStay's death.
Yes.
Yes.
And he was spending money to purchase fountains, right?
Yes.
Did you see that same evidence in the defendant's bank account, that he was spending money on purchasing supplies and fountains and things like that?
What we saw was evidence that the projects that were underway were completed.
Okay, that wasn't my question to you, sir. My question to you is, did
Your
you
Honor,
see
he's
evidence?
explaining, that's the explanation. Counsel obviously doesn't understand the question, doesn't understand the issue.
I specifically asked you about the defendant's bank accounts and whether or not you saw evidence of those same types of withdrawals for waterfalls, water features, supplies, and things of that nature.
I don't recall any specifics during that short period of time other than the completion of the jobs.
And again, you quoted this $207,000 again today as money that was taken in terms of water fountains and projects and on behalf of EIP, right?
Yes.
But the only knowledge that you have in terms of projects that were specifically taken in by EIP after the disappearance of the McStays on the PayPal records totals approximately $127,000, right?
On the PayPal records.
And the other deposits are cash, and you are attributing those to Earth-inspired products, even though you don't have any evidence of that, right?
No, the evidence is that they were deposited into an Earth-inspired products business checking account.
Well, that same business checking account also had a whole bunch of personal withdrawals from it,
Objection
right?
states the evidence.
The objection sustained is cumulative.
Did you look at those bank account records?
Yes.
And were there personal withdrawals from those bank account records?
There were withdrawals that we determined were personal.
And in your experience, is it uncommon for a small business person who has a bank account, even though it's a business bank account, they may commingle, right?
They may commingle, yes.
So that $207,000, where you're adding the cash deposits in, that's an assumption on your behalf because it was a business account.
So at the time, he had both a business account and a personal account. My experience with commingling is that generally it's businesses being run out of a personal account rather than monies out of a business account. Those typically done correctly are shown as draws. So it's less commingling and it's just compensation that's going to the owner as a draw. So there's distinction there.
Regardless of that fact, you didn't see any owner withdrawals, did you? In terms of that category
Well,
that you just described?
Those would have to have come through business records, and we weren't provided business records that would have reflected that.
And so if you testified previously that that Dan Cavanaugh's income had declined, but you weren't aware of any other source of revenue that he had, that would also apply to that additional monies that was cash deposits into those accounts, right? The EIP and personal accounts.
That would have required him depositing another business's revenue into Earth Inspired Products account, which I wouldn't have assumed as reasonable.
Well, you did take a look at that account, right?
Yes,
And there were personal expenditures from that account, right?
there were personal expenditures.
And with respect to the Geist construction project, you weren't provided, again, you didn't get any information on that. That's why it wasn't on your radar, right?
That's correct.
But it was in the bank records that you reviewed.
There was mention of it, yes.
I can have just a moment. I don't have anything else, Your Honor.
Mr. Molina, anything else?
Mr. Sjogren, counsel's asking about an income decline for Mr. Cavanaugh. When did Mr. Cavanaugh experience an income decline? When was he experiencing his income decline? Was it towards the end of his relationship with Mr. McStay?
Objection assumes facts not in evidence.
Was it before? I'll rephrase the question.
All right.
Was it before February 2010?
Yes,
And you actually did a chart in that regard, is that correct?
I did, yes.
We do have it marked, I just don't know the number. This has been marked as 11:30. We could switch to the overhead, that'd be great.
Can I see what it is that you're putting up?
It's 11:30. And I'm going to, because of the size, I'm going to take it out of this little thing here. I'm going to show it in two parts because it's a little. Let's see if I can blow it up a little. If you can just describe to the jury what we're looking at here. This is the top portion of that.
So this was a period of time that I labeled a income growth period starting in the third quarter of 2005 through the second quarter of 2007. That was a 23-month period, and there was a little over $100,000 of earnings over that period of time. And his average monthly earnings during that period of time were just short of $6,000, $5,828 during that time.
So looking at this graph, we're looking at a time period from the third quarter of 2005 to the second quarter of 2007. The second quarter ends in June,
That's correct.
so June of 2007. And it looks like you have an upward trajectory without going into specific numbers.
That's correct.
Starting at about $5,000 in the third quarter of 2005, and then going to the second quarter of June of 2007, going to about $18,000. Is that correct?
That's correct.
Okay. And that's what he would be making per quarter, correct? That's not a yearly figure, correct?
No, that's a quarterly.
Okay. So there's an upward trajectory in Mr. Cavanaugh's income with relationship to EIP for that time period.
That's correct.
Okay, so then the second part of the graph is taking it from the second quarter of 2007 to the first quarter of 2010. Is that correct?
That's correct.
Can you explain what we're looking at here?
Yes, and I'll point out that the scale is different here. This is 18,000, and the previous one, the top number, I think, was 25. So their scale is a little different. And this is just an anchor point. The new data starts here in Q3 and goes through Q1 of 2010. And we can see that there's a decline. And that decline, the average monthly in the last 4 quarters was under $1,000, where the average monthly in the previous area had been, previous slide had been about $5,800. And the biggest,
If you could just, those numbers, I don't understand what you're saying in terms of numbers. Maybe the jury doesn't either. So if you can just explain what you're saying so that we can understand.
So I apologize.
I guess my first question, just to make it easier, is Mr. Cavanaugh's income increasing like we saw before, or is it decreasing in this time period from 07 to 2010?
Right, so on the left-hand side here are dollars, and this is over time. And so over time, the line, this is a regression line, and it shows that there's a decline during this period. So for the quarter, there are two quarters that were high here in this, over $4,000 per month in these 2 quarters. There were some lower times here, but in this last little bit, in particular these 4 quarters that are here, and this only reflects January of 2001, so this is specifically 10 months. The average income to Mr. Cavanaugh during that 10-month period was just $967. And
are you saying he was making, at the end of his relationship, on average, $967 per month?
That's correct.
And in 2007, where you start this in the second quarter, how much would that translate into monthly income for Mr. Cavanaugh in that time period?
In the third quarter of 2007, this is just over $3,000 per month.
Per month. So from 2007, the third quarter, you're looking at monthly income of approximately $3,000 a month, going to the first quarter of 2010, where it's $967 per month.
That's correct.
Okay. And you did mention, and you were shown, various PayPal transactions that were between Joseph McStay's PayPal to, and money sent to Dan Cavanaugh's PayPal, correct?
That's correct.
And prior to Joseph's disappearance, would it be fair to say that those amounts were dwindling in amount in terms of the amount of those transfers?
Yes.
The last transfer being $25 on February 3rd, 2010?
That's correct.
After the disappearance, you did mention the approximately $9,000 that was taken in the first from February 10th to February 13th, correct?
I believe it was $7,900.
Okay. And then, of course, we've talked about the $207,000 that came in. I'm not going to get into that again. So in terms of when counsel was asking about income decline, this is the income decline you were talking about for Mr. Cavanaugh, is that correct?
That's correct, and it's largely attributable to the transition for the SEO work to Authority Domains from Mr. Cavanaugh. So it was just a complete loss of revenue for activities.
Are you saying that EIP or Mr. McStay started using and paying another company, Authority Domains, for work that Mr. Cavanaugh had previously been doing?
Objection calls for speculation and hearsay, lacks foundation. And it's also beyond scope.
Overall, we can answer based on his review of the records, what the records show in terms of his payments.
That's correct. The period of 4/19/06 to 7/8/08, there was $79,000 paid to Daniel Cavanaugh for SEO work, and the period of time 2/1/07 to 1/4/10, there was $90,000 for SEO work paid to Authority Domains.
In that same period, from 07 to 2010, how much was paid to Mr. Cavanaugh for SEO work?
So that crossover period, there was a time where Mr. Cavanaugh was paid an additional $40,350 to the number I previously said, and Authority Domains received $58,940.
You did a graph in that regard as well, correct?
I did.
This is Exhibit 1131. If you can just describe what we're looking at here to the jury, please. I'm going to zoom out a little bit.
If you could put this so that I can see these numbers, that would help.
Sure.
Great. So, in 2006, payments that were specified as to Mr. Cavanaugh for SEO work were just about $33,500, and there was none to Authority Domains. The colors are a little hard to see in this, but Cavanaugh is always on the left of these. It's the one that shows up as close to blue. In 2007, when both of them received pay, Mr. Cavanaugh got just slightly more than Authority Domains. By 2008, Authority Domains had taken over most of that work, and as you can see, it developed into 2009, and they had taken over all of that SEO work by then.
Okay. So, if I read this correctly, in 2006, virtually all the SEO, when we're talking about SEO, we're talking about search engine optimization, correct?
That's correct.
This is some type of work that computer people do to get your site at the top of the chain on Google and stuff.
It's putting the appropriate search words on websites so that when those of us who go onto the internet are looking for something, we would be able to find it. And they do their magic to get at the top of that list.
Okay, so again, in 2006, it was virtually all Dan Cavanaugh getting the revenue for that work.
Objection, that calls for speculation.
Objection sustained as cumulative.
In 2007, it's about equal split between Authority Domains and Dan Cavanaugh.
Objection cumulative. Objection cumulative. There's an objection, Your Honor?
I said sustained.
Oh,
I didn't hear you.
and by 2009, Dan Cavanaugh is out of the picture.
Objection, that calls for speculation.
Again, the objection sustained as cumulative.
The DA again asked you about these exhibits, the ledgers that you were talking about. those are ledgers that you did not have originally. Do I have that right?
Objection, asked and answered.
Sustained, cumulative.
Counsel then asked you about checks that were received by Mr. Merritt and in connection with this 65%, 15% model. She specifically asked you about checks after Mr. McStay disappeared, that Mr. Merritt got after Joseph disappeared. Now, if Mr. Merritt is receiving checks, that's money that he's getting, correct?
Yes.
Okay. But then, does something happen when he gets the money in terms of a receivable that he is due? Meaning, Mr. Merritt, if he receives money, I think you said that the receivable to Mr. Merritt triggers when the deposit is made. Is that correct? Is that your understanding?
That's my understanding of the relationship they had. When Mr. McStay received the deposit, then work would initiate on the project.
So
I'm sorry, when he received the deposit, work would initiate.
So when Mr. Merritt receives checks, that means there is a corresponding receivable to him, correct? Meaning, for that job, he's going to get a certain amount, whatever model we're using, 15 or 65%, correct?
Yes.
So if he's getting checks, then he has to deliver a waterfall, correct?
That's correct.
And he gets paid for that waterfall, correct?
The checks are payment for the waterfall or his manufacture of it or whatever the part of that work that he's doing, yes.
The 10% that you made, that you referred to again today about the checks, she said it was 10% of the material, the cost of goods. Does that have any relevance whatsoever after you found the ledgers?
No.
She asked you is it common to commingle? Do small businesses commingle? I think that was the question, correct? In this case, you did see a lot of personal spending from Mr. Cavanaugh during that 10-month period from February 2010 to December 2010, which would be commingling, correct?
Objection, speculation, relevance, and improper.
Any objection sustained on relevancy and cumulative.
You saw tens of thousands of dollars spent in nightclubs.
Objection
Objection.
assumes facts, not evidence, relevance, be
The
honest.
objection sustained on relevancy grounds it violates the court's previous order on the in limiting rulings.
Did you see commingling in the accounts as counsel asked you?
Objection asked and answered, cumulative.
Sustained on relevancy grounds and cumulative.
Nothing further, thank you.
Just briefly, did you do that
We'll
same?
take our morning recess in 15 minutes. Keep in mind the admonitions previously given to you, not to form or express any opinions about the case, not to discuss the case. We'll see everyone back in about 15 minutes.
15 minutes.
Record flip, we are back in session. Parties and counsel are present. All members of our jury or alternates are present. Ms. Rodriguez, you had something on recross?
Yes, just briefly. The analysis that you just did with respect to the SEO payments, quarter one, that wasn't finished yet for 2010, right?
That's correct. I said that was just January.
Okay, and so you don't know what the relationship was between Joseph McStay and Dan Cavanaugh with respect to money that was exchanged outside of SEO payments, right?
We know that there was money that was exchanged outside of that. What we know the most about is SEO, the SEO business. Yes.
But there was other money that was paid to Dan Cavanaugh from Joseph McStay that wasn't labeled SEO, right?
That's correct.
So you don't know if that was particularly for that or something else, right?
That's correct.
And you went through this sort of lengthy analysis that you did on the loss of revenue over a period of time for Dan Cavanaugh, right?
Yes.
Did you do anything like that for the defendant's accounts?
We did not.
And in terms of, I'm going to show you what's been marked as Exhibit 874. Have you seen this previously?
I don't recall seeing it, but
And if this was something that our expert or Mr. Weitzman testified about and created with respect to the defendant's bank balances, would that be something that would be important for you to review in your analysis?
well, we had his bank statements, so we saw this. I just don't remember. I don't recall seeing a graphic of it. So.
And did you do anything to calculate to determine if there's any loss of revenue to the defendant when that percentage model went down from 65% to 15%?
We did not. And now we did not analyze a change in profitability for that. As we talked about before, we knew that revenue would go down for that, but we did not attempt to look at profitability.
I have nothing further.
Anything else?
Counsel asked you about other money that was sent to Mr. Cavanaugh, or paid to Mr. Cavanaugh. You described, of course, the SEO work, but counsel asked you about other money. There was other money that went to Mr. Cavanaugh that you're aware of that was actually earmarked by Joseph. Is that correct?
That's correct. We put up two graphs, and one of them showed SEO went to 0, but there was still that average of less than 1,000 in all monies.
Did you review records and payments to Mr. Cavanaugh that were earmarked for buyout?
Objection beyond the scope.
Overruled. You can answer.
We did see 3 payments that had designation written on them on the memo line or some other form.
Okay. And were those checks or were they PayPal or both?
I recall that those were checks, 3 checks.
Okay. But so if there were PayPal or other payments for that, you don't know sitting here today?
I don't have a recollection of that, but I know that there were 3 checks.
Nothing further, thank you.
Anything else?
And there was still money given to Dan Cavanaugh after the last check that you saw that said buyout, right?
Yes, that's
Nothing
correct.
further.
Anything else?
The bulk of money that was transferred from EIP to Dan Cavanaugh was done after Mr. McStay disappeared, is that correct?
Objection beyond the scope. Ask and answer.
Sustained and cumulative.
Thank you.
Anything else?
No.
So I wanted to clarify one thing with regard to like maybe 2 or 3 exhibits. You had a couple of exhibits that showed the relationship of money owed between Mr. Merritt and Mr. McStay, correct? Over a period of time.
Yes,
And that changed as payments were made and work was done, correct?
that's correct.
So I think at one point, Mr. Merritt may have owed over $10,000 to Mr. McStay, and at other points, Mr. McStay may have owed more than $10,000 to Mr. Merritt, correct?
That's correct.
Okay. Then we got to a couple of dates, and there were a couple of different figures. There was a January 10th, 2010 date,
Okay.
which, according to my notes, it showed that the defendant had been overpaid $790.
Okay,
Can you find that, maybe?
I'll look.
I was hoping you would just remember it off the top of your
Sorry.
head.
Is this what we're looking at? Is that the,
I think so, let me see, and what date did I say? January 10th?
would be on the last page.
I don't see a January 10th on there. Okay, maybe that's not as critical. If I understood your testimony, or the way I understand it, the last date that you have a balance between the two of them is January 28th of 2010 and February 1st of 2010. And that balance was that Mr. Merritt owed Mr. McStay $15,045. Is that right?
That's correct.
So that's the end of that long
Yes,
running balance back and forth.
that's correct.
Okay. Then that $15,045, we also have two side notes on the Provencio job and the Levine job, correct?
That's correct.
And that reflects, those side notes reflect that Mr. Merritt was initially paid based on the arrangement when the deposits were made to VIP, correct?
That's correct.
And then subsequently, there was a dispute between Provencio and Levine where some of that money was taken back by them.
That's correct.
And Joseph was noting that you got paid this, there's some of that money came back from me, so there might be something between us. Is that right? Is that your understanding?
That's my understanding, that this was a notice, if you will, of something that's pending.
Okay, okay. But in your opinion, did not rise to the level of an additional amount actually owed to Joseph.
That's correct.
It was just something that we need to talk about this.
That's correct.
Okay, got it. Anything further?
No.
I just have one question. The judge asked you about the amounts, the last days that you had the amounts owed, and I think you indicated January 28th, and the judge also asked about February 1st. Is that the date of the balance on the 2009 ledger that matches with the date on the email? Matches with the email on February 1st.
So the ledger's total, the last entry on the ledger would be 12810, and that matches the number that's on the 2-1 memo.
That's the $15,045.
That's correct.
And there's also a line, we've seen it ad nauseum, but just as a reminder, above that, there's also the amount that, the $26,000 on the
Correct.
public.
Objection, asked and answered beyond the scope.
The objection sustained is cumulative. Anything else? Any objections to Mr. Sjogren being excused, subject to recall of course?
No, Your Honor.
Thank you, sir, for your attendance. You are excused. Just make sure you don't take any of our exhibits with you. Otherwise, we will have to bring you back. Okay?
Thank you.
Thank you. And you are still subject to recall, assuming the attorneys know where to find you if we need you.
I understand.
Okay. And I'm guessing we don't have our next witness here until...
No, we do. We have a witness here.
Oh, we do?
Yeah.
Okay, good.
We have the witness here, but we'll have to, we were planning for 1:30, so we have to get the transcript and so forth.
So you need a few minutes?
We need probably to 1:30 because I think the court had indicated that we were going to do these witnesses. We anticipated Mr. Sjogren going all morning, so.
Well, we were pretty close to that. So you want to take our noon recess
Yes.
now and then come back at 1:30?
Yes.
Okay. All right, we'll go ahead and take our noon recess at this time till 1:30 this afternoon. Keep in mind the admonitions previously given to you, not to form or express any feelings about the case, not to discuss the case or allow anyone to discuss the case with you or in your presence, and we'll see everyone back at 1:30.